Hey, good morning. It's Patricia Murphy. It's Tuesday. This is Seattle Now. The case of a Bremerton football coach fired for praying on the 50-yard line is in the hands of the Supreme Court this week. SCOTUSblog editor James Romoser is here to tell us what happened during Monday's arguments and what's at stake when the justices issue their ruling this summer. But first, let's get you caught up. There's some more help for Seattleites who fell behind on rent during the pandemic. Landlords will now have to offer payment plans, allowing tenants to pay back rent in monthly installments and with a cap on how big the payment can be. The law passed yesterday by the City Council goes farther than an earlier requirement, giving tenants up to 6 months to catch up. The law applies to any rental debts taken on during the city's ongoing COVID-19 civil emergency and up to 6 months after it ends. Microsoft's latest earnings report proves the company's pandemic growth hasn't slowed. The company posted more than $49 billion in sales in the first 3 months of the year, up 18% from this time last year. Profits rose 8% to $16.7 billion. And the Sounders have a shot at making some MLS history tonight. They're in Mexico City to play in the CONCACAF Champions League final for the club's first time ever, and hoping to become the first MLS team to ever win. They'll be up against the Pumas of Liga MX out of Mexico City. Tonight's game is the first leg of the final. The teams will be back at Lumen Field next week for the second match. The case of Kennedy versus Bremerton School District was heard in the other Washington this week. Justices on the Supreme Court are deciding if Bremerton High School football coach Joe Kennedy's rights were violated when he was ultimately fired for praying on the 50-yard line after games. The case centers around 3 First Amendment issues: the right to worship, the right to free speech, and the right of students to be free from religion imposed by school officials. With a 6-3 conservative majority on the court, some legal experts say it may be more sympathetic to Kennedy. James Romoser is here to talk about what went on this week. He's the editor of the SCOTUSblog, an independent source of coverage of the Supreme Court. Thanks for taking the time, James. Really good to have you.
I'm happy to do it. Thanks for having me.
So this is a local case that's gone all the way to the Supreme Court. Can you just give us a quick introduction to Joe Kennedy and tell us why he lost his job?
Joe Kennedy was an assistant football coach for Bremerton High from, I believe, about 2008 to 2015. For a number of years, he was engaged in the practice of saying a prayer right after every game, sort of at the 50-yard line. The school district wasn't aware of that for quite a while. When the school district became aware of his practice of praying on the field, it asked him to stop, because it was worried about violating the First Amendment's Establishment Clause, which prohibits the government from endorsing religion. And the school district was concerned that having a public school teacher, a public school official, a coach in a public setting with a lot of students around, and at times with some students participating, by saying a Christian prayer, it would appear to be a government endorsement or establishment of religion.
And, by this point, by the time the school district intervened, this was a ritual that was being participated in by students and other team players. And the decision in this case will go well beyond Joe Kennedy. Let's talk about that. What is at stake here?
Well, what's at stake is various types of prayer in school. And the case sort of involves the tension between the right of students and teachers in some settings to exercise their religion, of course. And the Supreme Court has said that students and teachers don't relinquish their First Amendment rights at the schoolhouse gate. And so there is room for free speech and exercise of religion and private prayer in schools, in public schools. But at the same time, the Supreme Court has also said that students need to be free of feeling coerced to participate in religion in a public school setting. And so there's a tension here between those 3 rights, actually. And the Supreme Court's decision in this case, depending on how narrowly or broadly a ruling they issue, will affect accommodations for religion in public schools and in other public settings as well.
Kennedy took this to the lower courts and lost. What was the argument in those cases?
So Kennedy sued the school district saying that he wanted his job back because it was a violation of his First Amendment rights to prevent him from having a job. There's some question about whether he was really fired or whether he just wasn't offered the job. But in any event, he sued to get the job back, and several lower courts issued several rulings against him, saying that the school district was well within its rights to be concerned about potential endorsement of religion that his prayers were causing. And so it was well within his rights to ask him to stop. And then when he didn't comply with the school district orders, it was well within his rights to not rehire him.
One thing that's really interesting to me about this is the Supreme Court already declined to take this case in 2019. What changed?
Well, that's a good question. It came up to the Supreme Court at an early stage of the litigation when a lot of the facts were still unclear. And the justices said, we can't hear this case now because the lower courts still need to sort out exactly what really happened. How private were these prayers? How public were these prayers? How many students were participating? How disruptive they were? There were all these thorny factual questions that the two sides really disagreed about. And so they sent the case back down to the lower courts for them to sort that stuff out. And now it's come back up to the Supreme Court. But once again, we have significant disputes about the facts. So I'm actually not sure what those couple of years of litigation in the lower courts, how much progress that was really made. Because as we heard during the oral argument on Monday, the two sides don't just have very different views of the law. They really have very different views of what even went on here during these prayers.
From listening to the arguments, James, what aspects of the case do the justices seem most interested in right now?
Yeah, well, it's interesting. The justices were sort of, all over the field, to pardon the pun, at oral argument. They each seem to have different theories or ways of looking at the case. Some saw it primarily as a speech issue, that this is, a coach's private right to engage in speech. Others saw it primarily through the lens of worshiping and freedom of religion. Samuel Alito suggested that this was really just a case of employment discrimination, that he lost his job for exercising his religion and that was inappropriate. And then some of the liberal justices and even Brett Kavanaugh, one of the conservatives, made some comments that expressed their concerns about the issue of coercion, specifically the idea that some players, some students, even if they didn't want to participate in these prayers, might feel pressure to do so to sort of get on the coach's good side.
Sure. And when you're dealing with teenagers, that's a significant issue. Also, I heard, what is a coach allowed to do during his private time during the day? Is he always on school time? Is there time for a brief moment of prayer? Very interesting issues, James. I want to hear what the attorneys were saying. Were there any important or notable moments coming from them?
Yeah, well, as you said, the justices were sort of posing a lot of hypotheticals because they need to worry not just about this case, but how the case will affect, other potential settings. So, questions like a teacher privately saying grace on her lunch break, or saying a short prayer right before the bell rings before she begins instruction, or perhaps right after the bell rings while the students are in the classroom. And so I think what you saw was both advocates trying to grapple with those hypotheticals and sort of point the court toward a narrow ruling in favor of their clients, without necessarily implicating some of these other situations, right? I mean, you even had Justice Sonia Sotomayor ask, what if a coach decided that it's his religious belief that he needs to wear a swastika symbol on his arm and kneel down and pray at the 50-yard line? And you sort of heard Paul Clement, the lawyer for Coach Kennedy, saying, well, there would be a question about whether that really is a sincere religious belief, but if it were, there would be no basis for punishing a coach for doing that if that really was his religious belief. And that is a pretty extreme argument. And I can certainly, understand why school districts would want to be able to discipline coaches for that sort of conduct.
What's your sense about the direction of this case after the arguments? Do the opinions seem to be leaning one way or the other at this point?
I think in general on Monday, we heard a lot of sympathy for the position of the coach from most, if not all, of the 6 conservative justices on the court. And they hold the majority on the court right now. In general, those 6 conservatives have been very willing to accommodate free exercise of religion claims. And they've been willing, in many cases recently, to expand free exercise rights, even if that has meant narrowing the scope of the other First Amendment clause, the Establishment Clause. Those conservatives have been, very willing to do that. And I think that you saw those attitudes expressed at oral argument on Monday. Now, that being said, there are ways that the court can resolve this somewhat narrowly, sort of confine it to just questions about brief private prayers without students being forced to participate. And you could get a narrow ruling and leave a lot of these other questions for another day.
Well, James, we'll likely hear more about this by the end of June, which is when the court has indicated it will issue a ruling. Really appreciate your time and your insight. Thank you.
Thanks so much for having me.
James Romoser is editor at SCOTUSblog. Thanks for listening. Jenny Cecil Moore produced today's show. Matt Jorgensen does our theme music. I'm Patricia Murphy. See you tomorrow.